Hi, and welcome to What's the Tea in L&E. I'm Leah, and I have today a very special guest, Patrick Bolling.
Hey there, thanks for having me.
Yeah. Well, Patrick does a lot with helping employers navigate through handling a union or advising them when there's sort of the infancy of union organizing on their work site. And so I wanted you to talk to a lot of our employers today about, we are so familiar with the EEOC and charges of discrimination. But I want to hear about the NLRB and charges related there. So tell me, what is the National Labor Relations Board?
So the board is sort of a pseudo-political body. It's based in D.C. It is the government agency, federal agency, that is responsible for oversight of union organizing activity and what are called Section 7 rights in the workplace, which is the right to engage in protected concerted activity aimed at improving working conditions.
Yeah, protected concerted activity. So sort of like employees banding together, right, to say, like, I want to make my workplace better. We need to fix safety issues here. We need more flexible scheduling. We need parental leave. We need higher pay. All of that would constitute protected concerted activity.
That's right. So long as it's aimed at improving the working conditions of one or more employees, even if the action is only taken by one employee, believe it or not.
Interesting. And so what about charges? My understanding is that an employee, right, can go and file a charge with the National Labor Relations Board. What does that look like?
So it's a lot like the EEOC. There's a charge of an unfair labor practice charge, it's called, alleging the violation of some provision of the National Labor Relations Act. And so a charge is filed, and then a board agent typically reaches out to the company and notifies them that the charge has been filed. There's an investigation process. There may be an early settlement. If not, then possibly a complaint is going to be issued, and there would be a trial in front of an administrative law judge that could be appealed to the labor board, and those labor board decisions could be appealed into federal court and then ultimately up to the Supreme Court.
Yeah, and we see a lot of looking at the news, right? I mean, we see a lot of employers that are facing these union issues or unfair labor practice claims in court. And one that came up recently that I wanted to talk with you about is one dealing with Home Depot and dress codes. I guess my understanding is Home Depot was either put in place a policy or re-emphasized their dress code policy prohibiting employees from wearing Black Lives Matter pins or sort of certain pins that were supportive of things outside of Home Depot, not Home Depot related, right? Not let's go wrenches in some way. So tell me and they face some sort of claim. Tell me about that.
That's right. It's important to remember that even if you don't have a union, the Labor Act still applies to you. And that was the situation in Home Depot when a number of employees, at least one initially, had on their orange Home Depot apron a Black Lives Matter pin. Home Depot said, look, this is a violation of our dress policy. You should take that off. And the employee, it doesn't have anything to do with work. The employee said, oh, yes, it does. I've got some complaints going about discrimination here at Home Depot in the workplace, and therefore there's a nexus between me wearing a Black Lives Matter pin and aiming to improve my working conditions at Home Depot. And the Labor Board ultimately agreed with that and held that that was protected concerted activity under the Act.
So what's our takeaway for employers? Like, if an employer either has employees who are advocating for other worker rights or improvements, how should an employer navigate that? Because it is protected.
Well, it's easy to slip up, especially because it's much less common for your frontline supervisors to be aware of labor issues when they've never had to deal with a labor union before. And so you need some training for your frontline supervisors about what they can say, what they can't say, just some basic backgrounds on union issues in the workplace when they may never have had to deal with it before.
Yeah, and also carefully taking those adverse actions. So if you need to discipline an employee or address a performance problem and that employee has engaged in protected activity, because you don't want it to look like retaliation, you need to be careful about that. Make sure your documentation is in line and handle that carefully and probably talk to counsel. So, well, Patrick, thank you for joining us.
Thank you.
It's been What's the Tea, and we'll see you next time.